contract in restraint of trade is one by which a party limits the other's ability to continue in his trade, business or profession in the way and with the people he chooses in the future. Such a contract is unenforceable under common law, but it might be enforceable in the case that evidence is presented that the restriction is fair under the circumstances as seen from the perspective of the community and the persons involved. Section 28 of the Contract Act 1950, every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. The meaning of the words to that extent void in Section 28 is if the agreement is split, it will remain lawful for the portion that are not damaged as being in restraint of trade. It is possible to argue that the use of these phrases gives the court the authority to enforce the agreement just to the extent that it complies with the section and not the rest. However, the agreement is null and void in cases where it is not so divisible. If separation would change the agreement's entire meaning and scope, it will not be permitted. In the case of Ringlesworth against Anthony Wilson, as agreement whereby an advocate and solicitor was restrained from practicing his profession within 5 miles from Kota Baru town for 2 years after termination of his service contract, was held to be void. The distance and place in respect of the restraint was irrelevant. Judge Hashim adopted the strict interpretation of Section 28 of Contract Act 1950 when he said, in my opinion, the case should be decided on the interpretation of Section 28 on the first paragraph of the plaintiff's letter to the defendants dated 7 December 1963. With great respect, I do not think the English cases are applicable as the Contract Act 1950 is not based on the English law of contract. Section 28 is quite clear, except in respect of 3 exceptions. Every agreement by which anyone is restrained from exercising a lawful profession is to that extent void. The defendant is an advocate and solicitor and can lawfully practice his profession in Malaya. The case of Polygram Records Sdn Bhd against the Search, after examining the English authority, Judge Visu Sinadure concluded in the case Polygram Records Sdn Bhd against the Search that the common law principle pertaining to trade restraint applies to evaluate the validity of such agreement and determine whether they were reasonable in light of the particular facts of the case. But the judge ruled that Section 28 of Contract Act 1950 only applies in situations where someone was prohibited from practicing their trade or profession after the agreement was made, not while it was still in effect.
And hello, I'm Ashwini Kumar. Do you guys know that there are some few exceptions for Section 28 of Contract Act 1950? Let's discuss about it. So basically, based on Section 28, generally any agreement that restrains someone from exercising a lawful profession, trade, or any business is void. But there are 3 key exceptions that allows certain restraints under specific conditions. And the first exception is sale of goodwill. What is goodwill? Goodwill is an intangible asset representing the value of a business, such as reputation, customer relationships, and brand strength, and so on. So basically, this exception applies when selling the goodwill of a business. And there are few conditions that need to be taken note to apply this exception, whereby the restriction must be within defined geographic boundaries. And this exception is valid as long as the buyer or the successor of the business continues the business in that area. And the reasonableness of this exception is the court must find a geographic limit reasonable considering the business nature. And what is the purpose of this exception? The purpose of this exception is to protect the buyer's investment by preventing the seller from starting a competing business immediately nearby. So let me give an example. For example, if you sell a bakery, you might agree not to open another bakery within a 10-mile radius. You got it? And the second exception is dissolution of partnership. This exception applies to partners agreeing not to carry on a similar business within specified local limits upon or in any anticipation of the partnership dissolution. So there are a few conditions for this exception, whereby agreements made when a partnership is dissolved or about to be dissolved. So the reasonableness of this exception is similar to the first exception, whereby the local limits must be reasonable. And this exception is not applicable if the agreement is not made in anticipation of dissolution or lack of specified local limits. So for this exception, there is one case that can be taken as an example, which is Nagadevan Mahalingam and Millennium Medicare Services. So in this case, the restrictive covenant was void because of 2 reasons, which is 1 was not made in anticipation of dissolution, and number 2 is because it did not fit within the exception criteria. So basically, the example that I can give is for this exception, when partners dissolve their law firm, for example, they may agree not to start a new firm within the same city. And boom, the third exception is during continuance of partnership, whereby the partners may agree that some or all of them will not carry on any other business other than the partnership during its continuance, whereby we have some few conditions for this exception, whereby restriction applies only while the partnership exists, and this exception restricts partners from engaging in any other businesses than the partnership business. The purpose of this exception is to ensure the partners focus solely on the partnership business activities without being distracted by any other ventures. And the example that I can give for this exception is, for example, partners in a consulting firm might agree not to start or join any other consulting firm where this partnership is being active. So to conclude all of this, exception number 1 is to protect buyers of business goodwill from immediate competition by the seller. And exception number 2 is to allow partners to agree not to compete within reasonable local limits upon dissolution of the partnership. And exception number 3 is to ensure partners are dedicated to the partnership business during its operation. So these exceptions ensures that while general trade restraints are void, reasonable protection for business interests are upheld. Understanding this exception helps businesses and individuals navigate agreements more effectively. Thank you.
According to Section 28 of Contract Act 1950, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void, including saving of agreement not to carry a business of which goodwill is sold.
In the exception, one who sells the goodwill of a business may agree with the buyer to refrain carrying on a similar business within specified local limits so long as the buyer or any person deriving title to the goodwill from him carries on a like business therein, provided that such limits appear to the court reasonable, regard being had to the nature of the business.
In the circumstances of Mrs. Tan, regarding to the restraint of trade clause in the sale agreement, Mrs. Tan was prohibited from engaging in a similar business within the same city for a period of 5 years after the sale. However, it is found to be a void agreement as it is unlawful to restrain anyone to carry on a business of which goodwill is sold, as being mentioned in Section 28 of Contract Act 1950. In fact, Mrs. Tan were actually interested with the customer base of Mr. Lim's business. Thus, it is also unreasonable to restrain Mrs. Tan from continuing the Mr. Lim business. The purchase of the goodwill of Mr. Lim's business soon will be meaningless for Mrs. Tan.
In the circumstances of Mr. Ahmad, regarding to the restraint of trade clause in the employment contract, Mr. Ahmad agreed for not to work for any competing electronic stores within a 10-kilometer radius of the business premises for the duration of his employment and for a period of 2 years after its termination. Based on Section 28 of Contract Act 1950, restraining anyone from exercising a lawful profession is said to be void. In fact, Mr. Ahmad is depending on his experiences and managing skills to seek for incomes. Thus, it is unreasonable to restrain Mr. Ahmad to continue to find a job within his profession. In the case Polygram Records Sendirian Berhad and the Search and Another, the plaintiff, Polygram Records Sendirian Berhad, Music and Sound Recording Company, entered into a written agreement with the defendants, the Search, a rock group. The clauses that prohibited the defendants from making any recording after the post-contract become unlawful restraint of trade and become void under Section 28 of Contract Act 1950.
According to Section 66 of Contract Act 1950, when an agreement is discovered to be void or when a contract becomes void, any person who have received any advantage under the agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it.
Based on Ms. Tan's situation, in an action of restoration, Mr. Lim shall return the amount of sales of the business to Ms. Tan, and Ms. Tan shall return the ownership of the business to Mr. Lim. If the restoration was already unable to be done, then a compensation, in commentary, a monetary compensation has to be done. If both of them were still interested to enter into an agreement regarding to the sales of the business, then a new agreement without the restraint of trade or any other unlawful clauses will need to be drafted by them.
Based on Mr. Ahmad's situation, although the restraint of trade clauses is void, however, the essential subject matter of the employment contract is still valid. The restraint of trade clause in the employment contract is to the extent void. Thus, Mr. Tan should allow Mr. Ahmad to work in his profession after the post-contract, and Mr. Ahmad will free to find a job in his profession after the post-contract.
Under Malaysian law, any agreement in restraint of trade is void unless it falls within certain exceptions. Section 28 of the Contract Act 1950 specifically addresses agreements in restraint of trade. It states that every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. However, exceptions are allowed if the restrictions is reasonable in the interest of the contracting parties and the public. The clause in question prohibits Ms. Tan from engaging in a similar business within the same city for 5 years. The clause's reasonables can be assessed based on its duration, geographical scope, and the necessity to protect the legitimate interest of Mr. Lim. In this case, a 5-year restriction within the same city may be considered excessive and unreasonable. The courts typically assess whether the restraint is reasonable to protect the goodwill being sold. Considering Section 28 of the Contract Act 1950, Ms. Tan should negotiate with Mr. Lim to reduce the duration and geographical scope of the restraint clause. A more reasonable period suggests 2 to 3 years and limiting the geographical scope to specific areas within the city rather than the entire city. If negotiation is not possible, then Ms. Tan could suggest incorporating a severability clause in the contract, allowing courts to enforce the reasonable parts of the restraint and strike out the excessive parts. So what are the legal strategies that Ms. Tan could take? Ms. Tan could engage a lawyer specializing in business and employment law to assess the enforceability of the restraint of trade clause and advise on possible modification. And the next one is Ms. Tan could proactive drafting contract for future business acquisition, ensure all contractual terms, especially restrictive covenants, are reviewed by legal counsel to avoid overly restrictive terms that could impede business operations.
Section 28 of the Contract Act states that agreement in restraint of trade, including non-compete clauses, are void to the extent they are deemed unreasonable. Mr. Ahmad has the right to assess the reasonableness of the clause, considering factors such as its duration, geographical scope, and potential impact on his future job prospect. If Mr. Ahmad believes the non-compete clause is unreasonable and overly restrictive, he has the right to challenge its validity. Section 28 allows parties to void agreements in restraint of trade that are deemed unreasonable. Mr. Ahmad has the right to negotiate with his employer to amend or remove the non-compete clause if he finds it unfair or burdensome. Section 29 of the Contract Act permits parties to restrain trade to the extent necessary to the protection of their legitimate interests. Mr. Ahmad has the right to seek legal advice from lawyers specializing in employment law or contract law in Malaysia. A legal expert can provide guidance on the enforceability of the non-compete clause and potential legal avenues available to challenge it. If Mr. Ahmad determines that the non-compete clause is unreasonable or unenforceable, he has the right to take proactive measures to mitigate its impact on his future job prospects. This might involve seeking employment opportunities outside the restricted geographical area or exploring alternative career paths. Mr. Ahmad has the right to stay informed about development in Malaysian employment law, particularly regarding non-compete clauses. This will enable him to make informed decisions about his right and option under Contract Act. By exercising this right under Section 28 and 29 of the Contract Act in Malaysia, Mr. Ahmad can navigate the implication of the non-compete clause in his employment contract and appropriate action to protect his interests.